Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Well, I got to give it up to you, New York. You are a glutton for punishment because we have done already way too many videos here at Washington Gun Law about what's going on in New York. And yet again, I get to do another video because it appears that the appellate courts have a big problem with your red flag laws as well. So let's get everyone up to speed on what's happening in New York because I think this has the potential to have some very far-reaching implications. Today, let's spend a few minutes and talk about why are New York's red flag laws unconstitutional. Okay, so the case we're talking about today is out of New York. It's a case called GW versus CN. That's a real exciting title, but this is what happens when courts leave people anonymous in these things. This is a red flag petition out of the state of New York. Now, we have already done videos on red flag laws, extreme risk protection orders, both on a statewide level and on a federal level, and I have explained what I believe are some of the numerous procedural deficiencies as it relates to the implementation of red flag laws, not only as it tramples on an individual's Second Amendment rights, but also predominantly on their Fifth Amendment rights of due process under the law. Now, the state of New York, like many states, says that an extreme risk protection order, red flag order, can be brought either by law enforcement or family members. Interestingly enough, in New York, the law used to read that if law enforcement were to receive information of an individual who might be subject to a red flag law, they could bring a red flag order. New New York law now says that law enforcement must bring a red flag order. So if they receive any information that a person potentially poses a harm to themselves or others by having access to firearms, law enforcement in the state of New York is now mandated by law to petition for a red flag order. Well, in this case, CN was having nothing of the red flag order that GW was petitioning against them, and in fact hired an attorney and said, you know what, not only are we not going to acquiesce to this, we're going to object to it because we believe that New York's red flag law is unconstitutional. And here's the kicker. The judge agreed. You see, the Honorable Judge Thomas Moran of the New York State Supreme Court has ruled that New York's red flag law, specifically New York CPLR 63A, is unconstitutional. Now, before you all start celebrating and saying, oh, this means that red flag laws everywhere around the country are now unconstitutional, au contraire. First of all, this ruling has very limited reach as far as who it affects. And secondly, you have to understand the reason by which the court found this unconstitutional. I got to give it up to the attorney here who argued on behalf of the respondent here. This is a really, really well-crafted argument. It's very smart, and it really hits on one of the things that I find to be most important in law, which is consistency. I believe that laws should be applied as consistently as possible throughout any spectrum of life. Whenever there is the ability to equally and consistently apply the law, that's the way it needs to be done. And that was what the problem was that the judge had with New York's red flag laws. You see, the argument was essentially this, is that, you know, if we want to take a person and involuntarily commit them into a mental institution in the state of New York, we have to prove that they pose a clear and present danger to themselves or others. Interestingly enough, when we want to get a red flag order against the person, we also have to demonstrate the exact same thing, that they are a clear and present danger to themselves and or others. But here's the thing. When you are going to put a person involuntarily into a mental health commitment, under New York law, that opinion that this person poses a risk to themselves or others has to come from, shockingly, ready for this, a medical professional, such as, oh, I don't know, a doctor, a psychiatrist, somebody like that. And here's the thing. If a person is going to be held for any longer than 48 hours against their will, there must be a second medical opinion which also states that the person is a danger to themselves or others. So when we're going to involuntarily commit a person, take away their right of freedom, okay, their Fourth Amendment right against unreasonable government searches and seizures, New York is very particular that, hey, listen, we need valid medical opinions that are justifiable from a medical standpoint before we go locking this person up. So is the same thing then required when we take away a person's Second Amendment rights? Oh, no, not at all. Not at all. Because what the New York law required is that somebody makes some kind of allegation that some way expresses that this person might be a danger to themselves or others. So whether that comes from a law enforcement officer who's operating only on hearsay material, or if it's coming from a family member who obviously is emotionally attached and probably not professionally qualified to be making these diagnoses, this is the standard by which we were taking people's Second Amendment rights in violation of their Fifth Amendment rights, and yet it is inconsistent with what we are doing with the exact same category of individuals when we're trying to involuntarily commit them. The court specifically stated, the question presented is whether CPLR Article 63A sufficiently protects a New York citizen's due process rights when, as here, the state denies a fundamental right, to wit, by infringing on the citizen's right to keep and bear arms under the Second Amendment of the United States Constitution. This court holds that CPLR 63A does not sufficiently protect the citizen's rights and therefore is unconstitutional. So that is the basis by which they struck this law down. Now, there was more to it than that, too, because one of the other things that the court pointed out is, like, you know, when we have people involuntarily committed, we do these routine status conferences. We make mental health professionals come back and provide evidence to the court, hey, is this person still in such a mental condition that they should continue to be involuntarily committed? Or has their condition improved to such a degree that perhaps they should be released from that institution? And that is required by New York law consistently when we have people involuntarily committed. Once we have a red flag order on a person, do we have any of these status conferences or anything of that nature to make sure the person's coming along there? No, not at all. Not at all. Because once the order is entered, it is going to remain in effect until the order expires. There is no ability for a citizen in New York to undo that order, even if in the event that there was a legitimate medical issue and now that legitimate mental health or medical issue has been cleared up, the order will remain in effect until its expiration date. And here's the other thing that the court pointed out, which is, hey, listen, you know, when we decide to sign an order and we're going to take away all of these person's guns, you know, in a lot of areas of New York, we have people who are cohabitating. We have roommates. When you go in and start seizing the firearms of the person who's subject to the red flag order, oftentimes all firearms in that location will be confiscating, including those of people who have nothing to do with this and have not done anything at all to warrant the forfeiture of their Second Amendment rights. So the case, once again, is GW versus CN. And listen, this is the important thing to take from this, which is that there are a lot of other states where their red flag laws are structured in almost an identical fashion as New York. Maybe it's more discretionary instead of you have to file for an ERPO or a red flag order. But beyond that, when you take a look at the standard of proof that's being articulated here, yeah, it is bare allegations without any medical documentation whatsoever, without any medical diagnosis whatsoever, that's being used to forfeit a person's civil liberties. Now, when we take a look at what states are doing, though, when you want to involuntarily commit a person, and any defense attorney who's ever dealt with people who are mentally incompetent, you know how hard it is to get them involuntarily committed. You know it is virtually like throwing rocks at the moon, and there needs to be a mountain, an absolute mountain of medical evidence before a court would even consider forfeiting their civil liberties on those grounds. Why then? Why then, when we talk about another right in the Bill of Rights of equal importance, should it be treated any differently? Listen, we will continue to track this case. We're sure the state of New York is going to appeal this. We have proven time and time again that they are not particularly good losers. We will keep you posted about any updates. In the meantime, if you got any questions about this or what's left of your Second Amendment rights, you know the drill. You can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.